Will I have to meet a pretrial probation officer in the first 30 days after a DWI arrest in New York? Attorney Martin Kane explains that. The only time you have to meet in a pretrial probation situation in Queens County is because of a relatively new program for people who are on the borderline of whether they should be released without bail. Defendants are now sometimes released subject to supervision by a court agency that stays in touch with them and makes sure they follow the correct path. There is obvious advantages for somebody who might not otherwise be released. In DWI cases, defendants will be directed, usually at arraignment, to be assessed by the Office of Alcoholism and Substance Abuse Services to determine if they require alcohol treatment. It is usually helpful if a defendant does the assessment as soon as possible. Often, no treatment is suggested. If treatment is required, it can be started as soon as possible. Either outcome can be used by your attorney to obtain a better outcome of the case. Additionally, there is a lot to discuss with your attorney. Your attorney is going to want to know every detail of what happened. He is going to want to know everything he can about your background. Therefore, your attorney is going to try and get as much information as he can in his first interview. New questions arise that have to be answered. It is likely that your attorney is going to want you to come back and see him as many times as necessary. A good attorney is not going to skimp on the amount of time that he spends with you, and every case is different, but you should expect to see your attorney multiple times before you go back to court. For a free phone consultation, contact attorney Martin Kane in Kew Gardens, New York at 718-793-5700 or visit www.martinkanelaw.com.